To that time of turmoil for Australia's car manufacturing industry. Of course, Toyota announcing this week its decision to close manufacturing facilities by 2017. 2,500 workers set to face job losses, and it's expected many more employees across the automotive industry supply chain will suffer from the flow-on effects. Well, here to discuss the likely impacts of the closure, our regular guest commentator Joydeep Hor, Managing Principal of specialist law firm People+Culture Strategies. Joydeep, always great to see you. Yeah, just firstly, I mean, if we could start with the industrial relations system here. I mean, as Kieran was just mentioning there, the former head of Toyota Australia in the AFR today saying that combative industrial relations helped trigger Toyota's decision to stop making cars in Australia. Things need to change, he says. What's your view? I mean, is that the state of play now?
Yeah, I think the first thing is that only a corporation, only a business knows what the real reasons are for the decisions that it makes. And while the public is entitled to speculate, and certainly from a political point of view there's lots of arguments that could be run, no one really has that full insight in terms of the whys and wherefores other than the management team and the leadership team of Toyota in this particular case. I think the issue that has caused some controversy, I think quite rightly so, is that towards the end of last year, Toyota made an application in the federal court to try to alter the terms of its enterprise agreement. Now, it's worthwhile reflecting that an enterprise agreement, or EBAs as they used to be known, are in place for a certain period of time, and that's a matter that is negotiated between an employer and typically unions on behalf of employees. So you talk about making a one-year agreement or potentially up to a 3 or 4 year agreement. It's so important for a business that it factors in what might be the scenarios that it is likely to face, having regard to its best data, the economic circumstances, both known and forecast, over the life of that particular agreement. What Toyota probably paid a price for was perhaps a level of optimism at the time that it was making that particular agreement. Circumstances changed quite drastically from all the information that's been shared. It's then left with no choice but to go to its workforce and say, we want to make these changes to the agreement. If the workforce is going to be resistant to that, as is the workforce's right in those circumstances, well, you then have to go to the federal court and ask for that agreement to be changed. The federal court in this case said, well, no, you can't do that. Now, is that a fault of the system? Well, the system is the system, and it has been the system in terms of enterprise bargaining in Australia for many, many years. I think the lesson for this, for all employers, is that when you are in the context of bargaining with a union, you just have to be really careful. You can't make the decisions as to what you commit to purely because you think that things are going to turn around or that you'll be able to ride through a difficult period. If you have even the slightest inkling that circumstances are going to be tough and you're going to need to, you might not be able to honour the terms of a particular agreement, well, you shouldn't be making that particular agreement. Now, yes, there's been a lot said about the generosity or alleged generosity of the terms and conditions of this particular agreement. Well, there are other agreements in Australia in a lot of other industries that are as generous, if not more generous. Those employers in those industries have made a decision to agree to that, but they could well face the same situation as well. So I don't think the system itself should bear the brunt of all of the criticism. I think big employers like Toyota should have the sophistication and the access to the necessary resources to be making deals that they can stick to, or at the very least maybe shortening the term of an agreement, make it for 1 year and then revisit it at the end of the year. That gives you a lot more flexibility. Sure, it's a bit more time consuming, but there's a lot that can be done within the parameters of the current system.
And just in terms of, from an employment law perspective, when a business like Toyota shuts down car making in Australia, what exactly happens? What's the process?
So if there is an agreement in place, an enterprise agreement, then typically that agreement will deal with matters such as the obligation to consult with the workforce, consult with representatives. It'll deal with obligations such as how much notice is to be provided. It'll deal with obligations such as how much redundancy pay or severance pay, and that might be quantified on a number of weeks per completed year of service basis. So it'll deal with all of that machinery. And one of the interesting things about this particular agreement was that there's some provisions in there that say in the event of redundancies, the company will discuss with the union the precise mechanisms by which people will be transitioned around the further assistance to be provided. So arguably some of that's not even set in stone. That's unusual. Most unions certainly will like to have the certainty of, well, there's going to be redundancies. We want the certainty of X amount of notice, X amount of weeks, severance pay, etc.
And just in terms of, helping workers transition, into some sort of other employment, I mean, is there a legal obligation on Toyota to do that?
Well, the period of notice that's required to be provided to an employee in this situation is very much designed to at least give some time for them to transition to alternative employment. So if you are on notice from your employer for whatever reason, then theoretically that is giving you some opportunity to start testing the market. The fact that you get severance pay, and depending on how long you've been there, that could be quite a generous amount of money, tides you over at least in an income sense. But all of that assumes that the market is buoyant. It assumes that people who are out of a job, are unemployed, will be able to pick up employment even within a couple of months period. Now, some people will, some people won't. That's just the reality of the job market at the moment. So, yes, there is a legal obligation in that sense, but I think a lot of employers then also have to ask themselves, what's the ethical obligation here? And one of the best things that employers can do in these circumstances is advance notice, keeping employees abreast of the economic circumstances of the organisation, so that when unfortunate announcements like this have to be made, and hopefully from an Australian economic point of view they don't have to be made too often, but when they are made, employees are not completely taken by surprise in relation to it.
And just finally, I mean, back to obviously what you were saying there about the federal court ruling against Telstra, against Toyota in this case. What's your sense then of the system? I mean, there was some murmurings that perhaps, maybe the Abbott government would have a look at the, what happened, with the fact that the enterprise agreement couldn't be altered. I mean, is the system broken? Do you think that, I mean, I know you were saying that, with Toyota, perhaps the length of the agreement was too long. They were too optimistic when they signed it, agreed to it. I mean, but do you think that there is an issue with the system?
I think that the framework for the system is solid. I think there's certainly room for improvement around tweaking it. I think employers have, for many years, probably been a bit fearful of taking a confrontational approach in relation to enterprise bargaining when it comes to unions. There's been a fear of industrial action and a lot of other consequences, and they're all legitimate fears, but I think that it's that classic decision that an employer has to make, which is, yes, we could agree to this and we could lock away a deal, an agreement with our workforce, we get industrial harmony, but in circumstances where we might need to change, well, we might not be able to do anything about that. Is that the better decision, or do we say, no, we just can't agree to the terms that are being sought? Our business circumstances are our business circumstances. Nothing's giving. So these are the important decisions from a strategic and tactical point of view that employers need to make.
Yeah. Joydeep, it's always great to get your insights. Thank you so much for joining us. Joydeep Hor, their Managing Principal, People and Culture Strategies. Stay with us, plenty coming up on